Okay, welcome to the Education Full Committee. Let's start out by everyone, make sure you're signed in for the, so we can take our roll. And give a few seconds. Will the clerk please take the roll? Okay, Madam Clerk, take the roll.
Mr. Chairman, you have 17 members present. Mr. Chairman, you have a quorum.
Thank you very much. And we also have, I know we have a lot of members floating in and out other committees during this one, state and local, I think, and others. And so they'll be moving out. So we just watch our, if you leave, just let us know, watch our quorum. I don't think that'll be a problem. But also, as we move through the bill. Today we have about, we've got 38 bills, I think, left on our calendar. We're meeting today for till 1 o'clock, and then we'll come back in here tomorrow. What's the time tomorrow? Come back here tomorrow at 1:30, and we've got the room till we finish. So kind of be prepared to, let's try to complete the calendar by tomorrow afternoon and see if we can get down to maybe moving all the bills to the floor or wherever they may go. So members, any recognitions, any, okay, Representative Mayberry?
Hey, members, I have a shadow today, and he is from Stewart County High, and his name is Zach Childers. If you could stand up here in the room. Where you at? There he is. If you welcome him today.
Very, very well. Anyone else need recognition or announcement? Probably about 12 o'clock, I've got my Germantown Municipal School District. Some of those students, we've got 8th through 12th graders that are up here visiting our Capitol Day. They'll be floating in. We'll recognize them when they come in. Chairman Sapik, can I see your hand?
You did, Mr. Chairman. I want to recognize, we have a new employee, Lou Henman from THEC is here, and he brought his daughter with him, Rosemary. If you could welcome Rosemary here. Welcome, Lou. Welcome, Lou. Welcome.
Wonderful. Wonderful. Okay, we're going to open up with the prayers we usually do. I'm going to call on Representative Mayberry to open us with that prayer. And we're also going to remember our Montgomery County students that was mentioned yesterday that we lost. So Representative Mayberry.
Yeah, thank you, Mr. Chairman. And yeah, committee, Montgomery County suffered a terrible tragedy this week where we had a terrible crash where 2 students have lost their lives in Clarksville, Montgomery County from Kenwood Middle School. So we're going to put in prayer and remember them. So let's pray. Father God, today we thank you for this committee. We thank you for the business that we get to do for the state. Lord, we pray that you'll give us wisdom, guidance, and direction today, Lord God, for every single member. I thank you today for Montgomery County, the loss that we have suffered, Lord God, and it hurts deep within our community, Lord. I just thank you for bringing us peace that surpasses all understanding. The Kenwood Middle School community, we pray for them. We uplift them, every teacher, every student, Lord God. And I thank you, Lord God, for the families from these students, Lord God, who lost their lives, Lord God. I ask that you just be there with them, comfort them, and bring them peace today, Lord. We just thank you for your direction in Jesus' name. Amen.
Amen. Thank you very, very much. Okay, members, as we begin the calendar, as you see, we are go in this order at this point unless we need to move out of order for any particular reason. I would just ask that let's move smartly through the calendar. Let's discuss the topic. And always, if we get on political issues, just make your case and then let's move on and keep the committee running well. Yes, members, to begin with, just so you know, item number 25, House Bill 2226 has been taken off notice. Item number 29, House Bill 2227 has been taken off notice. House Bill 30, and item 30, House Bill 778 off notice. Oh, House Bill 448, I'm sorry, 448 off notice. And number 31, House Bill 1740 off notice. Those 4 are off notice. Any further on that? Okay, if not, let's just go ahead and begin the committee. We're going to start with item number 1, House Bill 640 by Representative Carringer. You have a motion and a second. Let's make sure your bill is in order. Do we have amendments?
Yes, there was one that was added,
And that would be,
014870.
that is what we have. Motion on the amendment. Have a second? I'll give you a second. It does make the bill, so any objection to us adding this to the bill for proper discussion? Hearing no objection, all those in favor say aye. Opposed? The ayes have it. Representative Carringer, you recognize.
Thank you, Chairman and Committee. House Bill 0640 is that this bill just does 3 things. It requires the department to provide guidance to Tennessee Accelerating Literacy and Learning Corps, to the members and tutors, that aligns these tutoring services to the students' remediation needs. It will allow the department to provide a report on the effectiveness of these remediation programs, and it will require the department to provide a list of IT systems to LEAs that can measure students' progress for these remediation services, while also making sure the data is protected. No LEA will be required to use any IT system. And this is just a permissive bill to go across the state of Tennessee in order to help the LEAs to be able to track their students' progress better. So with that, I will stand for discussion.
Okay, with that explanation, members, questions, Representative Carringer? I see no questions. Is there any objection to me calling the question on House Bill 640? Hearing no objection, Madam Clerk, put the vote on the board. Madam Clerk, take the vote. Oh, wait, did everybody get a chance to vote? I'm sorry. Have you already taken it? Can you hold up? If you haven't taken it, hold up 1 minute. You've already taken it?
Mhm.
Okay. Madam Clerk, give the vote.
Mr. Chairman, you have 12 ayes and 0 nays.
Okay, House Bill 640, the majority does pass out to calendar rule.
Thank you, Chairman and
Can we
Committee.
get Representative Hakeem, make sure his voting is working? Members, that brings us to item number 2, House Bill 2129 by Representative Alexander. You got a motion and a second. Representative, give us your amendments.
I have amendment, 012160.
How about, look, you see, you got 15370.
I do. I'm sorry. 15370. Sorry.
You got a motion and you got a second, and it does make your bill, I understand.
Yes.
So any objection to adding it to the bill for proper and full discussion? Hearing no objection, we are now going to add, all those in favor say aye. Those opposed? Okay, 15370 is added to House Bill 2129. You're recognized.
For a long time, I believe that, thank you, Chairman. Thank you, Committee. For a long time, I believe that preschool was very important, and we could possibly need that to improve our reading literacy by the time they get to 3rd grade. But after consultation, and I know Chairman White, myself, Chairman Hicks, all worked on trying to come up with what's the best way. And we don't want to ask the state for money for preschool until we know how much money we need, until we know how programs work. And so this bill just asks for a TASER study, and that study will include a statewide inventory of public education preschool programs, including voluntary and state-supported VPK and special education and locally funded programs. It will also include the actual cost to the school districts for operating these programs. It will also include current funding sources and amounts, state, local, federal, and other grants, including analysis of gaps between funding and cost. It will also do an assessment of access, participation rates, and unmet need. It will also be a comparison with other states' preschool systems which were applicable. And it will also policy options and recommendations for future program development, anticipated need, and sustainable funding strategies. And with this, I renew my motion. I've spoken with TASER. They are well aware of this. And I thank you, Chairman White,
Thank
for
you
your
for that.
help.
Thank you for the explanation. Since it is a task study, we will, if it passes out, send it to finance.
Sure.
Okay. Members, questions, Representative Alexander on her, Representative Hicks?
Thank you, Mr. Chairman, and Representative Alexander. Thank you for your hard work on this. This is important to communities and getting kids on the right start. And it's extremely important to our district. So thank you and we need to study this. We need to work on this. So thank you very much.
Thank you.
Thank you, Chair.
Thank you, sir. Anyone else? Questions for Representative Alexander, House Bill 2129? Seeing no questions, any objection to the question? Hearing none, Madam Clerk, would you put the vote on the board? Representative Hakeem, are you square now? Okay, thank you. Everyone voted that's not in another committee? Can Madam Clerk take the vote?
Mr. Chairman, you have 14 ayes and 0 nays.
Thank you. House Bill 2129 moves out to Finance Committee.
Thank you, Chairman. Thank you.
Okay, members, I have a couple of bills. This has been backed up to the end of the calendar. I'm going to pass the gavel down to Chairman Raper, and while I present these, and he will take over. Might have to make sure you have it a moment.
Item number 3 on the calendar is House Bill 2095 by Chairman White. Thank you. After properly being motioned, do we have amendments on the bill?
Okay, yes, sir. 13606.
That is correct. After properly motion, those in favor, please do so by saying aye. And all opposed? Thank you. It's attached to the bill. Okay. Next will be, I'll call on Chairman White to present your bill.
Sure. Thank you very much, Chairman Raper. Members, this bill was brought to me by Tennessee Higher Education Commission. It's one of their annual cleanup bills. It mainly deals with modernizes statutes and removes obsolete language. It strengthens oversight and compliance. It improves financial aid administration, enhances transfer pathways, updates reporting for better data, supports governance flexibility, and expands apprenticeship opportunities is the language in this particular bill. The House Bill 13606 was an amendment that was added that deals with foster child tuition grants. It gives eligibility up to 6 years to a foster child as long as the student maintains satisfactory progress. That's part of it. We do have THEC here willing to testify if we have detailed questions about any of the language. And with that, I renew the motion.
Chairman White, would you like that testimony?
Don't require it unless the committee does.
Chairman Speaking.
Thank you, Mr. Chairman. Question on the bill.
The question has been called. Are there any objections? Seeing none, Madam Clerk, if you will put it on the board for vote, all in favor, vote aye, and all opposed, no. Has everyone voted? Madam Clerk, please present the results, please.
Mr. Chairman, you have 15 ayes and 0 nays.
The bill passes and travels to GovOps. Okay. Next bill is Calendar Bill 4, which is House Bill 2096, and it's also by Chairman White. after being properly motioned, are there amendments?
There
Chairman
are,
White?
let's make sure we have them in order. Are they, these two right here? Okay, 15272.
Second. Yeah. Seeing no objections, all in favor, say aye. All opposed? The amendment is attached, and it looks like you have a second amendment, Chairman White.
Yes, that would be 16421.
That is correct. It's properly motioned. All in favor, say aye. All opposed? That bill is also attached. And Chairman White, you were introduced to speak about your bill.
Talking points. Thank you very much. Let me get to my talking points here real quick. This deals with school board meetings. Here we go. Members, what these two amendments do, 15272 and 16481. This was brought to me. School board meetings conducted by electronic participation must have a quorum physically present at all meeting locations. As you know, we have to, the school board has to meet physically present. But because of the ice storm, because of the tremendous storm we had this past January or last year in some parts, this bill says a board meeting may be conducted by electronic participation if a quorum of members are present, and if inclement weather or natural disasters makes physical presence impractical or unsafe, but they cannot do this any more than 3 times per year, and all members participating must be visually identified in order to have these 3 meetings with electronic participation. And 1640 Amendment 16481 was language adding the public charter schools to the same language as the public schools, which they all are, but we always had to have that language. And with that, I renew my motion.
Chairman White has renewed his motion, and are there any questions on the bill? Seeing none, are we ready to vote? The call of the question. Madam Clerk, please put it on the board, please. Are all votes in? Madam Clerk, would you give the results, please?
Mr. Chairman, you have 15 ayes and 0 nays.
Thank you. The bill moves to calendar and rules. All right. Next bill is calendar 5, number 5 on calendar, and it's House Bill 1973 by Chairman White. Do we have a motion?
Motion.
After proper motion, Chairman White, do you have amendment on the bill?
Yeah, let's look at 15473.
Second. It's been properly motioned. That is correct. And all in favor to attaching to the amendment to the original bill, say aye. Aye. All opposed? It's attached to the bill. And Chairman White, you're recognized.
Thank you, Chairman Raper. Members, this is brought to me by the State Board of Education. It just deals with 2 things. They're updating their breach of employment contract, which removes outdated provisions requiring LEAs to file complaints for breach cases, deletes superfluous due process and administration requirements tied to breach cases. The State Board is not positioned to adjudicate employment contracts. It's a third party. So it just language around that. And the second part is a language about discipline of educator, license or teachers engaging in sexually related behavior towards a student. So there's language there, just redefining and strengthening that about making sure that our teachers and our students, there's no grooming involved and things like that. And so it's just language around that. And with that, I renew my motion.
Chairman White has renewed his motion. Are there any questions? I see no questions. Are we ready to call the question? We will do so. Madam Clerk, please put on the board, please. Everyone voted? Okay. Will you announce the results, please, Madam Clerk?
Mr. Chairman, you have 14 ayes and 0 nays.
The bill moves to calendar rules. Okay. Next, we are on number 6 on the calendar, House Bill 1974 by Chairman White. After properly motion, do we have an amendment?
Would it be 14856?
Or do we have a motion, after properly motion? I will say, all those in favor, do we have a question? Okay. All those in favor, say aye. Aye. This is attachment to the bill. All opposed? It is now attached. Chairman White, you recognize.
Okay, thank you, committee. Thank you for your patience. This is my last one today. The next one, I'm going to have to roll to the hill due to an amendment that we're getting on it. But House Bill 1974, this one was brought to me by a parent. I was talking to a parent actually out of Knoxville this past fall, and they brought something to my attention that they were having issue with. They had a daughter in the school who, excuse me, who even though there was not the actual sexual rape or anything, but that she was being sexually molested by another student. And she went to the court and got an order of protection. But when she did, it didn't change anything at the school. The perpetrator, the male student, was still in the same classroom with her, and nothing had changed. So even though she had an order of protection. So what this puts in place, if a court issues an order of protection under Tennessee Code annotated Title 36 and Chapter 3, and both the students attend the same public school, the school must create and implement a student safety plan as soon as possible, but no later than 5 days after receiving the protective order. The protocol for giving the order of protection is to notify the school administration, campus security, school resource officer. The school principal and the school safety team must, when that's applicable, must develop the safety plan with input from the parent or legal guardian of the protected student. The plan is specifically for the student who requested the order of protection or requested protection, who has the order of protection, or the petitioner. And so there must be physical separation of the two students. The school must separate the students as much as possible, which may include removing the perpetrator, the student who has the order against, from shared classes, adjusting schedules to avoid hallway contacts, assigning different lunch and break locations, and preventing contact at school events. The principal decides what, to the greatest extent possible, this means. In other words, what we're trying to do is make sure the school has a policy in place that when a parent has an order of protection, that the perpetrator is not in the same classroom or in the other events throughout the day there. In this particular case, it was just went on and made the young lady feel very, very uncomfortable, and there was nothing being done. So that's why we designed this bill. It went through several amendments trying to get where something we could do. And I hope that it does have an effect on make sure if we have issues like this, we protect the student. With that, I renew my motion.
Okay. Thank you, Chairman White, for the explanation. We have questions of Representative McKenzie.
Thank you, Mr. Chair. And for the first question, I think I need to go out of session and ask legal a question.
With no objections, we are out of session.
Thank you, Mr. Chair. To legal, an order of protection, I thought an order of protection was only filed against family members, spouses, girlfriend, boyfriend, kind of a thing. Is that correct?
Legal, if you'd like to respond, please.
Thank you, Mr. Chair. Katie Robertson, Legal Services. So an order of protection could be filed between two students. Say if there was a sexual harassment claim between the students.
Okay, and does the order of protection acknowledge guilt or innocence, or is it just to separate the two people?
Orders of protection generally are occurring without a hearing of testimony of guilt or innocence.
Okay, those are the two questions for legal.
We're back in session.
So,
All right, and we have a question on the bill. Representative McKenzie.
thank you, Mr. Chair. So, you know, as you explained the bill, there was statements about perpetrators. I think this bill, and I get an abundance of caution, but and I can see in a classroom, but in a high school, it's extremely difficult to separate the people, and there's no presumption of guilt or innocence, as we heard. And you have basketball games, football games, you have the cafeteria, you have the common entryways into a building, and most of our schools now only enter to one or two places. They keep most of the doors locked. This would be extremely hard for a high school to enforce. Again, I get the sentiment of the bill, and I definitely can see keeping them out the classroom together, taking classes together, unless they're both in like AP classes, something that has a limited number of offerings. But this could be very injurious to people. And I hate to say it, on the other side, it could theoretically be used in a frivolous manner. Not to say that it was here, but it could be. So this to me is dangerous to set a statewide mandate on a policy based on, I would say, no presumption of guilt or innocence.
Yeah.
Chairman White, would you?
Yeah, and President McKenzie, thank you. I understand this is why we did go through several versions of amendments trying to get here. You're right, but an order of protection, if a parent goes and get a court order of protection, however that process works out, the public school is required to serve both students. And this is where the hangup was in this particular one, is that the school did not they just said, well, the respondent, which I'm calling the perpetrator, so they have a right to an education also, as well as the student who had the offense committed against him. And the mother is saying, yes, but separate them. At least he was sitting behind her in the same classroom, same science class or biology class. And so this is an attempt where the school has to serve both students, and nothing was being done. They did ignore the order of protection. So I understand what you're saying, but this is an attempt that we can say, look, school principals, leadership, when you have a situation like this, make every attempt. You got to serve both students, but you also have to protect the defendant and the innocent party in this particular case. I hear you, but we need to do something.
Representative Barrett, you're recognized.
Thank you, Mr. Chairman. Just to address the concern of the member asking about the process as it relates to orders of protection, there is due process that's afforded in these cases. There's a process for applying for an order of protection. Often they are applied for and obtained through an ex parte hearing where evidence has to be put on, testimony has to be put on. A judge has to determine that there is probable cause to authorize them issuing the order of protection. And then there's also follow-up hearing for the defendant to come before the judge and address those concerns before the court to allow the court to determine whether or not that order of protection should remain in place. So this is not something that would be issued willy-nilly without some sort of basis presented to the court to show that there has been some sort of relationship between the parties, and that relationship has led to some sort of harm or offense or fear of future danger, and that fear has to be determined to be reasonable by the court. So I think it is incumbent upon not only us, but the school system to honor those orders by the court and do whatever is possible to protect these students who don't have a choice, because under the law, they still have to attend school. They don't get to drop out or stay home just because they're in fear of other people in the school building. So I applaud the chairman for trying to do something to put a policy in place and force the LEAs to take these matters seriously. So thank you.
Representative Johnson, you are recognized.
Thank you, Mr. Chairman. And I guess the thing that I'm thinking about is, especially in our smaller rural schools where they may not have as many course offerings, or with high school, you've got to get your required credits if there's not another course offered at the, that person could take, but it's required for both students. Are we going to put a student behind in their requirements because they're not able to stay in that class because you have groupings that students have to do with either voc tech classes or their electives, that sort of thing. So what about in the situation where there's no class that can get them the credit that they need? What's going to happen there?
Chairman White.
Yeah, that's one of the things, thank you, Chairman Raper. It's one of the things we discuss, and especially in a smaller school. But what we're asking for is every attempt to be made. A lot of times there is a solution if you got to find it. And let me point this out. I didn't mention this at the beginning. It is the responsibility of the parent who had the order of protection instituted, that if anything changes or if it's canceled, that they have 48 hours to contact the school and make sure, let them know that it's been removed. But back to your question, this is something that, it may come back to us next year that we say, okay, how do we deal with this issue? They're dealing with it. But I think 99% of the time, there could be accommodations made to make sure that all students feel safe when they're in school if things like this do happen. So I think the good outweighs the difficulty.
Representative Stevens.
Thank you, Mr. Chairman. Representative Barrett explained the order of protection process, but I also wanted to add this, that my understanding is that orders of protection are civil cases. And so you don't have the presumption of guilt or innocence. The standard that the judge uses is preponderance of the evidence, which is just 51%. In a criminal case, it's beyond a reasonable doubt. So on these civil matters, it doesn't matter if somebody's guilty or not guilty. The judge is looking for preponderance of the evidence. And I think that's important to remember, that nobody has been found guilty of a crime necessarily. This order of protection is just a civil case that keeps the people separated until it's dissolved by the court.
Are there other questions? Seeing none, we will, any opposed to calling the question? I see none. Madam Clerk, will you put on the board, please? All in favor say, not say aye, but vote aye, and all opposed, no. Has everyone voted at this point? Madam Clerk?
Mr. Chairman, you have 14 ayes, 0 nays, and 2 present not voting.
Thank you. And this travels to calendar and rules. Okay. Next on the calendar is number 7. It is House Bill 1977 by Chairman White. And I think this is the one you referred to as far as rolling to the Hill. Am I correct?
That is correct. We're going to roll that to the Hill. There's an amendment that was brought to us late, and we're going to deal with that. So we will roll that to the Hill at the request.
It's rolled to the Hill.
Thank you, Chairman Raper, and thanks for the patience of the committee to get through those that were backing up towards the end. We're now on item number 8, House Bill 1833 by Chairman Sapicki. You have a motion and a second. Chairman, could you give us a bill number, amendment number?
Drafting code 013346.
That is correct.
It does rewrite the bill.
It does rewrite the bill. Do I have a motion second on the amendment?
Motion.
Okay, any objection to adding the amendment to the bill for proper discussion? Hear no objection. All those in favor say aye. Aye. Ayes have it. We're now on your bill, 1833, Chairman.
Thank you, Mr. Chairman. Members, what this bill does is a couple things for our higher education. First of all, it redistributes how we're going to choose our THEC advisor, our THEC board. It'll be made up of the 3, 3, and 3 that we have been doing across education right now to make sure there's balance to the board. 3 of the appointees will be made by the governor, 3 by the speaker, and 3 by the lieutenant governor. What it also does is it changes our graduation rate for on-time graduation. THEC talked about this early in the year in their presentation, going away from, on a bachelor's, going away from 6 years to going to 4 years, and on an associate's going from 4 years to 2 years. And remember, on-time graduation, we just count full-time enrolled students, full-time enrolled students. It also talks about in THEC on the grad rate, they have to look at this every 5 years to reevaluate. And then what it does is when these schools come before THEC and asking for an increase in tuition and fees, they give a base recommendation that every higher ed department can take, or every college can take. However, if they want to get above and beyond the recommendation in this bill, it states that they have to show an increase year over year in their grad rate to get something above and beyond what they want. So THEC will make a recommendation of tuition and fees increase year over year. And then if they want to go above and beyond that, they just have to show an increase in their graduation rate as described in the bill. And then the last thing what it does is our Tennessee colleges and universities have had a huge influx of out-of-state students coming into our schools, generating millions and millions of dollars. What the last part of the bill does is it requires our colleges and universities to come up with a plan on how they can use the out-of-state tuition and fees to drive down the cost of our in-state tuition and fees for our Tennessee kids. That's what the bill does, Mr. Chairman. I'll be happy to answer questions.
Thank you. Great explanation. Members, with that explanation, 1833, we're open up for questions, discussion. And I understand you worked closely with THEC on this.
Oh, yes. The new guy, Lou Hammond.
And his daughter. Right. All right. Any discussion? Seeing no hands up. Any objection to the question being called? Seeing no objection, Madam Clerk, put the vote on the board for HB 1833. Madam Clerk, take the vote.
Mr. Chairman, you have 15 ayes and 1 nay.
Okay, House Bill 1833, receiving majority, moves out to calendar and rules. Thank you, Chairman Spicki. You're also on item number 9, House Bill 1960. And motion is second. I don't see amendments on this one.
No, sir. No, sir.
You're recognized.
Thank you, Mr. Chairman. Members, what this bill does is currently in our
Do
tier
I have a
3.
motion and second?
Oh, sorry.
Got a motion there. Go ahead.
Currently, members, in our tier 3 intervention with our priority schools. Tier 3 is the schools that have been performing very, very poorly in the state of Tennessee. Currently, state law says that they have to go to the Commissioner of Education and explain a turnaround plan and make a recommendation to the commissioner. Currently, the commissioner has the ability to accept that or make a recommendation for closure, period, in the story. We have a new Commissioner of Education coming in. We don't know who that's going to be. What this bill does is provide another level of security for our districts and for the General Assembly that states once that decision is made by the commissioner will take that decision to the State Board of Education that we appoint, we have control over, and the Commissioner of Education shall make that final declaration to the State Board, and the State Board can give an acceptance, a denial, or come up with something that they want to do. It gives us another layer of protection so that it's not just an arbitrary decision of one person. It's a board making a decision which could be closure of a school in Tennessee. That's what the bill does. I'll be happy to answer questions, Mr. Chairman.
Okay, there's a thorough explanation. Questions on the House Bill 1960? I see no questions. Any objection to the question being called then? Hearing no objection, Madam Clerk, please put the vote on the board. We're on House Bill 1960. Madam Clerk, take the vote.
Mr. Chairman, you have 15 ayes and 0 nays.
Okay, House Bill 1960 receiving a majority moves out to calendar and rules. Thank you. Chairman Spicki, item number 10, House Bill 2000. You got a motion and a second. Are we dealing with amendments?
No, sir.
Right. Okay, you're recognized on House Bill 2000.
Thank you. Members, just very simply authorizes a private post-secondary institution including one that is religiously affiliated to establish a public charter school in the state of Tennessee. That's what the bill does, Mr. Chairman. Happy to answer questions.
Okay, that explanation before us. Questions from the committee? Representative McKenzie, and then we'll go to Johnson.
Thank you, Mr. Chair. I'd like to go out of session and ask legal one question.
Any objection? We're out of session. Legal? You go ahead and address your question.
Thank you, Mr. Chair. Is this constitutional?
She's legal, you recognize.
Thank you, Mr. Chair. Katie Robertson, Legal Services. The AG opined in November 25 that, in his opinion, current practice likely violates the free exercise clause of the First Amendment of the United States Constitution. This is deleting those portions in which he has found that it likely violates the free exercise clause to be in compliance.
You follow up on the legal, Representative McKenzie?
So help me understand. So the AG is saying that we have to let religious schools be part of our charter school system? Is that what you're saying?
Legal?
The Attorney General's opinion, yes, he finds that based on analysis of 3 recent free exercise clause cases that have come from the Supreme Court recently, based on those cases, that it is likely that current law in Tennessee would violate the free exercise clause as to the prohibitions of religious entities being available to open a public charter school in Tennessee.
Representative McKenzie?
I'll have a question for the sponsor, but I'm.
Anyone else while we're out of session to legal?
I'd like to ask a legal
Representative Johnson, you're recognized for legal.
So in Tennessee, and according to the Tennessee Constitution and Tennessee law, a public school can be religious, is what you're saying?
Legal?
The Attorney General's opinion looks at, I believe it's the LeBron case, to determine what is a public entity versus a private entity. And based on the LeBron decision, the AG opined that public charter schools would be a private institution, and therefore the free exercise clause would apply to them. In the LeBron decision, to determine what is a public versus private entity, it looks at how the board is created and the government control.
Follow up?
Yeah, well, I guess this is incredibly interesting. I've been saying for a long time that charter schools were not public schools, and I guess we just proved it, or at least our AG has agreed with me. So that's nice. But I think that in this case of this particular decision, that opinion may not be exactly right. So I still have grave concerns about that. But thanks. It's nice to know that the AG of the state said charter schools are not public schools, as we've been trying to say. Thank you.
Chairman Speaker, do you have a question of legal while we're out? You're recognized.
I believe in the language of the bill, the religious school would have to maintain a non-sectarian academic day for the students, so therefore protecting the individual rights of the students. Is that correct?
Legal?
That is correct. The requirements that the curriculum would be non-sectarian still applies as it does in current law. It's just the bill is removing the requirements that the sponsor of a public charter school is the religious or church related.
Chairman Speaker.
And a follow-up to legal on that. So basically, if a Lipscomb University wanted to create a charter school to create opportunity for the public school students in Metro Nashville, this bill would allow them to do it. However, they would have to maintain their non-secular status when they're teaching the students. Is that correct?
Legal?
That's correct.
Thank you, Mr. Chairman.
Anyone else have a question of legal? If not, we are now back in session and further questions of Chairman Sapicki, Representative McKenzie.
Thank you, Mr. Chair. And I really hope the maker of this piece of legislation and others that probably have 29 behind it in the years to come heard what my colleague from Knox County heard from legal. If you're not going to be able to protect this standard that charter schools are public schools, and if I heard that once, I've heard that 300 times this 114th General Assembly. You're not going to be able to protect that. So that's one piece. But I would say more importantly, this country was founded not on Attorney General Skermetti's partisan opinion. And he's telling you, he said it, and legal said it. This current Supreme Court has a huge partisan slant. So these things are sliding by. Not that it's constitutional, because the Constitution is clear. The First Amendment is clear. You cannot use public money to aid a religion or a religious entity. You can't do it. You can't use public monies to aid a religion. And that's protecting the religion. So let's be clear. This isn't anti-church. This is pro-church.
Thank you.
Thank you, Mr. Chair, but I do have a question.
Well, go ahead and ask the question, then I'm going to
All right.
move
Thank you,
back to
Mr. Chair.
Chairman Sapicki. Go ahead.
How in the world can we have public dollars to fund a religious and assist a religious entity in educating our children?
You asking that question, Chairman Sapicki?
I am.
Okay, Chairman Sapicki.
I guess my question back is, do you mean like the Education Freedom Scholarship that we do already? Those go to private religious high schools across the state of Tennessee. And from what I understand, that has not been challenged in court. And what the AG is saying is we should afford the same opportunity to our private four-year institutions that are religiously affiliated, as long as they don't teach a secular curriculum. And I think the opportunity that we would have, if we look past what's in front of us, if we look at the opportunity that's before us to challenge this and say, hey, our institutions should have the right to provide high quality education to our high school, our elementary students, our middle school students, and we stay within the law, I think everybody would be on board with that. But I think the answer to your question is we already do this with the Education Freedom Scholarship.
Mm-hmm. Thank you. Let's go to Representative Boso. You have a comment, question?
Thank you, Mr. Chairman. It's more of a comment just to protect the record. I mean, my good friend from Knox County just said that under the First Amendment, public dollars cannot go to religious institutions. That simply is not correct. And the evidence of that is Chief Justice John Roberts' opinion on June the 20th of 2022 in the Carson versus Macon case, which explicitly held that the state of Maine could not prohibit parents from taking dollars from their Education Freedom Scholarship Fund and using them at religious schools, as Maine tried to do. In fact, that practice is not something that just occurred recently. It goes all the way back to the 19th century when during the 1860s and 1870s, there was an effort to keep any funds out of religious schools. And some states adopted these things called Blaine Amendments. And you may remember Representative Blaine because he was a nominee for the Republican nomination for president in 1876, ultimately, of course, losing to Rutherford B. Hayes. But the idea that somehow what this bill provides for or what the law in the United States of America is violated is simply not true. I'd also refer you to the U.S. Supreme Court's decision in Espinoza versus Montana, on which Justice Roberts relied heavily in his Carson versus Macon opinion. That's my comment, Mr. Chairman.
Thank you very much. Members, I think that everyone got their question in. You have one more, Representative Johnson, then we'll move on. Go ahead, you're recognized.
Yeah, this gives me great concern. The Tennessee Constitution is clear, prohibits state mandated funding of religious institutions, stating no preference shall be given to any religious establishment or mode of worship. Dictates that no person can be compelled to attend, erect, or support any place of worship. My tax dollars are going to support someone's religious teaching now with vouchers. And if there hasn't been a challenge, I think there certainly should be. This is just not something that I can support. Thank you.
Thank you. Chairman Speaker, I'd let you have the final word.
And I'll be very brief. Once again, in the language, it clearly states that it has to be a non-sectarian curriculum, which therefore aligns with our public schools. And if a private institution that is religiously affiliated wants to adhere to those guidelines, we should be able to have students be able to have the opportunity to attend those schools.
Okay, Representative Johnson, last word.
In Knoxville, we have a charter school that it's in my community. And if you talk to folks that, oh, my kids go to the Christian school, I'm like, what school are you talking about? And it's that charter school because it is associated with a religious organization loosely, but that's how they refer to it. I'm not sure where they're getting that, but that's what they're getting.
Thank you. Great discussion. Any other members want to comment? Any objection? Representative Barrett?
Sorry, I know we were getting ready to vote and we probably already know how this is going to go, but I just want to ask the sponsor, just for clarity on charter schools, are they zone schools or do parents get to choose whether or not they send their kids to charter schools?
Chairman?
Charter schools are open enrollment. The parents have to choose to want to attend that school.
Thank you.
Thank you. Okay. I have nobody else on the list. Any objection to the question being called on House Bill 2000? Hearing no objection, Madam Clerk, put the vote on the board. Madam Clerk, take the vote.
Mr. Chairman, you have 13 ayes and 3 nays.
Okay, House Bill 2000 with the majority moves out to Finance. Thank you. Good discussion. Okay, but we're now on item number 11. I see Chairman Slater made it back into the room. House Bill 1759, Chairman Slater. You have a motion second on the bill. You do have an amendment, I believe.
Yes, thank you, Mr. Chairman. That drafting code is 016147.
You got a motion second. I see where it does rewrite or makes the bill. So any objection to adding it to the bill? Hearing no objection. All those in favor of adding the amendment to the bill for proper discussion, say aye. Aye. Opposed? The ayes have it. Chairman Slater, you recognized.
Thank you, Mr. Chairman. And members, 600,000 working age adults in Tennessee lack a high school diploma. I mean, that statistic is alarming. 600,000 working age adults lack a high school diploma. What this bill does is that it adds to our existing law related to adult high schools, but then puts together a framework for adult charter schools. And that's what the bill does, and I stand ready for any questions.
Thank you. Let's open up for discussion. Start with Representative Johnson.
Wow. Charter schools are typically owned or run by hedge fund managers, and I see these folks are really good at finding ways to make themselves some money. But we have so many ways, in our traditional public schools where we can give adults services and they can get those degrees. I don't understand why we're heading in the direction of incredibly costly charter schools for adults. That boggles the mind. Can you tell me where this is happening and are the seats full wherever these exist or will exist?
Thank you,
Chairman
Mr.
Slater.
Thank you, Mr. Chairman. And currently, there are no adult charter schools in Tennessee. That's what this bill does. There are other states that do have adult charter schools. Probably the state that has the ones most closely aligned to what this bill does for Tennessee is Indiana.
Yes, and if I can give the committee a little background also, I've been working on this issue for like 10 years in Memphis. We have 120,000 adults within the city of Memphis who do not have a high school diploma. And so we've been working on this. We had what is known as the Excel Center down there, who started all this. And when I started working about 10 years ago, they were a K through 12, in the K through 12 space, not adult charter. And they were only getting partial funding. They were ready to go out of business. And we amended things throughout the years, and they are doing quite well. There is a big need, and ever since that time, I think we've had over, I didn't write it down, I think over 1,600 graduates in the last 8 years. This is a high school diploma, not a GED or a high set. And what they do, this school, these are people who dropped out for one reason or other, many times no fault to their own. In their mid-20s, going on 30, they'll come back to this high school to get their diploma. And the reason this is important is because this section of the population cannot get into trade schools, TCATs, community colleges, or anything else until they get that high school diploma. So therefore, these people are just locked out of the workforce market. And so we've been working on this for 10 years, and we now have we have one big school. We're opening up 2 more down in Memphis, but working on the 3rd one or 4th one, and we're now trying to figure out how to do this statewide. Because we always talk about Dry to 55. Well, there's 600,000 people out there that will never get into Dry to 55 until we figure this out. And so what Chairman Slater has been working with is, okay, here's a formula that we could probably do. Mainly it would be in Nashville next, where we have those who want to do it. But there is a big need for this. This is one way of looking at it. It's not like K through 12 charters. This will be, we're calling them charters in the adult space, so that we can get this going. But there is a great need for it. And like I said, we've been doing it for 10 years in Memphis, 8 years in operation, and we're graduating hundreds every year, and it's making a big effect. But so Chairman Slater, I didn't mean to take up your time.
No, thank you for your comments, Mr. Chairman.
Representative Johnson?
Yeah, well, we've been doing it forever in Knoxville through our through public schools. We have an adult school. We've got Paul Kelly Academy. We're able to accommodate everybody who comes without opening an expensive charter school.
Okay, thank you. Anyone else, members? Further discussion? We're on House Bill 1759. I don't see any other discussion. So any objection to me calling the question? Hear no objection. Madam Clerk, put the vote on the board. Madam Clerk, take the vote.
Mr. Chairman, you have 13 ayes, 2 nays, and 1 present not voting.
Thank you, Madam Clerk. House Bill 1759, receiving the majority, moves out to GovOps. Chairman Slater, I think we're item number 12. You're recognized.
Thank you, Mr. Chairman. If we could roll this to the heel of the calendar.
Members, without objection, item 12, House Bill 1880, going to the hill. Item 13, House Bill 1934. Chairman Slater? You got a motion and a second?
Thank you, Mr. Chairman. I have an amendment 014627.
One second, hold on just a second.
Yeah, hang on, just let me give you a different drafting code.
Sure.
016319.
That looks correct. You got a motion second on the amendment. It does rewrite the bill. So any objection to adding it to the bill for proper discussion? Seeing no objection, all those in favor say aye. Aye. Opposed? The ayes have it. moves out, does move to the full bill for proper discussion. We're now on House Bill 1934 is fully amended. Chairman Slater, let me take a second. I think this is the Germantown Municipal School that's with us today from in our community. This is my district I represent, and I spoke to him earlier on the House floor. Thank you all for being here. These are 8th through 12th grade students interested in government, and they're having a field trip to Nashville today. So y'all welcome. Excuse me, Chairman Slater, we're now on House Bill 1934. You're recognized.
Thank you, Mr. Chairman. And this bill requires the Department of Education to annually collect and report specified data on the department's website regarding the performance of Opportunity Public Charter Schools. And the data that is included is clearly listed in the bill.
That's your explanation at this point. Okay, I do have one question. I may have to go to legal for proper thing. In section 3, item 2, without objection, which one are we on? Okay. I think those are 14. Okay, I've got too much paperwork up here. Let's ignore that. Chairman Slater, you're recognized.
Thank you, Mr. Chairman. I renew my motion.
Okay, further discussion from the committee. Seeing no further discussion, any objection is called on the question. Hearing no objection, Madam Clerk, put the vote on the board. Madam Clerk, call the vote.
Mr. Chairman, you have 16 ayes, 0 nays, and 1 present not voting.
Thank you, Madam Clerk. House Bill 1934 received a majority, moves out to calendar and rules. I think we have another one under Chairman Slater. You are item number 14, House Bill 2177. Got a motion and a second. Let's look at it. We have amendments we need to address.
Yes, thank you, Mr. Chairman. Drafting code 015989.
You got a motion and a second. I see it does not rewrite the bill. Would you explain it to the committee before we look at adopting it? Would you let me go?
Thank you, Mr. Chairman.
You're recognized.
So it adds the commission to a couple of different sections and then also makes a technical correction related to the date at the end.
To the date. Members, with that explanation, any questions on that? You made a motion on the amendment? Oh, you have a question on the bill. Okay. Okay, any objection to adding the amendment to the bill for proper discussion? Seeing no objection, all those in favor of adding amendment 15989 to the bill indicate by saying aye.
Aye.
Opposed? The ayes have it. Okay, Chairman Slater, or we can go to Representative Johnson. Go ahead. Go ahead, explain the bill.
Yes, thank you. Let me give a brief explanation, members. Thank you, Mr. Chairman. This bill requires authorizers to annually notify each authorized public charter school of its renewal status and to publish that status in the annual authorizing report. This is important, members, because sometimes between the authorizer and the charter school itself, there has not been proper communication on a regular and routine basis. And so what this bill does is mandates that annual communication between the authorizer and the school. In addition, this bill requires automatic renewal of qualifying high-performing public charter school that meets specified multi-year performance, growth, and financial standards. So this is a very high standard, but a charter school that does reach this high standard will be given an automatic 10-year reauthorization. And then as far as substantive portions of the bill, because there is quite a bit in here, the third substantive portion of the bill is that it specifies that a public school or a public charter school with less than $50,000 in combined total funds from its internal school fund and student activity fund is not required to conduct separate audits for each fund. So this portion of the bill actually is for all schools, all public schools. And of course, charter schools are public schools, but all public schools in the state, there does not need to be a separate audit if there is $50,000 or less in a fund. Those there is still an audit, but there doesn't have to be a separate audit. For example, let's say that there's an athletic account of some type. As long as it doesn't have more than $50,000, then that can be included in the overall audit, and it doesn't have to be duplicated. This will save our public schools, all public schools, and especially these funds, money, because they don't have to have two audits. And with that explanation, Mr. Chairman, I stand ready for questions.
Thank you very much. Committee, I'll open up to the committee first. If not, I do have a question of legal I'd like to ask. Representative Johnson, you want to go first?
Thank you, Mr. Chairman. So did I see, maybe this is no longer in the bill, is there something in the bill about a charter school student being able to be on a school board, the student rep on a school board?
Yeah, Chairman Slater.
Thank you, Mr. Chairman. Yes, and I believe if section 1, so that is correct. That is still in the bill. There, as you can see, there is a lot in the bill, so I hit those three most substantive portions. But yes, it does allow for a student to be on the board.
Thank you. And there are so many traditional public school kids that would like that opportunity to be on the school board. Charter schools have their own boards. Maybe they could be a student rep on the charter school board, but I don't believe that they need to be a charter school rep on the board that actually is not the main governing body for their school. I have a problem with that. And I think we just heard from our AG that charter schools aren't public schools. But thank you.
Representative McKenzie.
Thank you, Mr. Chair. So I'll stay on that one, on that issue. That's really not fair. Knox County has one public charter school with a few hundred kids. We have 14 high schools, I think 30 middle schools. And the one public charter school is K through 8, I think. So that person gets an opportunity that I would say thousands of other Knox County kids would never have. And there's no connection between the two. I guess my question is, why is this even in this bill? And if you were going to put it in, why would you not at least have it reciprocal? Why wouldn't you allow a public school student to sit on the board of the charter school? So whatever logic that came up with this, putting that person on the school board, why would you not at least have it reciprocal?
Chairman Slater, would you like to respond?
Thank you, Mr. Chairman. And really, the only answer that I have to that is that's not what this bill does. Certainly, any one of our 99 members are more than welcome to bring that type of legislation, and it would go through this body, and we would consider it. Before us today is a student member on the board of the charter school.
One follow-up.
Thank you. It's so unfair to throw something like that into this big of a bill. Like you said, there's so much in the bill that you forgot that part. That wasn't substantial to you. Yes, it is. It's extremely substantial to the state. So my other question that I have for you is what we discussed last week, I'm sorry, to give these charters a pass, basically a 20-year license to practice without any intervention based on what I would consider, you said extremely high, not extremely high, better than average. I would say B, a B. If they make a solid B on their assessments, as these, see, look at these kids out in the high schoolers and middle schools out. If they make a B on their assessments, they get an automatic pass on average. But there may be some kids that are failing woefully that you're not looking at because the aggregate is satisfactory or hits a mark. I would think that the charter review process that this body set up meant something and was an important thing to go through. You allow them a span of time, 10 years, but then you need to take another look to see, okay, are you focusing on your high achievers at the detriment? Or are you focusing on your low achiever and missing that band in the middle? We're not going to be able to look at these charter schools won't be looked at for 20 years if we pass this piece of legislation. That's dangerous.
Thank you, Chairman Slater.
Thank you, Mr. Chairman. I would just point out that I mentioned 3 substantive points. 2 of those had to do with this 10-year automatic renewal, but one of them also had to do with the fact that they will be looked at annually. So we are taking looks that have not previously been done. And I'd also point out, too, that this does not change the testing requirements that students will take. Parents will receive those, the school will receive those, the state will. This doesn't change any testing requirements. I think we're putting in a great level of accountability and transparency and communication between the authorizer and the school itself, and also streamlining the process so that those high achieving schools can have an automatic renewal. Thank you, Mr. Chairman.
Thank you. If I have permission of the committee, I would like to request, I do have one question. If we could go out of session, any objection, go ahead. I want to ask legal a question. Seeing no objection, we're out of session. Legal, I just want to make sure this is brought to me right before I walked in. So see if I can explain this. In section 3, item 2, the language is each LEA shall within 30 days after the beginning of each fiscal year submit to the commissioner a complete and certified copy of its entire school budget for the current school year that is signed by the director of the schools and the local legislative body. That's what I want to highlight. That serves as a funding body for the LEA. Is this language any different than it has been in code before? Legal?
Thank you, Mr. Chair. Katie Robertson, Office of Legal Services. The difference between current law and this subdivision 2 is that is signed by the director of schools and the local legislative body that serves as the funding body for the LEA. Currently, it is only required that it be a certified copy, but this is requiring that it also be signed by the director of schools and the local legislative body.
Does it give them any more authority than what they've had in the past in this particular bill?
As far, you're talking about the local legislative body?
Correct.
No, it does not give them any more authority as far as the budget goes.
Okay, thank you. That addresses my question. We're out of session. Anyone else? So you know, we're back in session. Have one more, then we'll move on to got Chairman Haston up next to be ready. Representative Hakeem.
Thank you, Mr. Chairman. Chairman Slater, in regards to this automatic renewal, is this something that we found in other states that we automatically renew after 10 years? And is there a lack of transparency or I say accountability when you have timelines that are that long? If you could give me some insight on that.
Chairman Slater. You recognize? Oh, Mike.
Thank you, Mr. Chairman, and thank you for your question. Let me answer your first question first. I don't know if there may be, but I'm not sure as it relates to other states. Then secondly, I would point back to the fact that this legislation does two things in relation to this, and which I've already stated, so I'll be very quick about it. And that is that it does give that 10-year renewal, but it also creates a mandate that the authorizer and the school must be communicating on an annual basis. But then thirdly, what I'd like to do is just share with you why this is a high bar. Now, members may disagree with whether or not this is a high enough bar, but let me just share with you, in my opinion, it's a very high bar for these schools in order to earn this 10-year renewal, which I suspect, based on these criterion, that it is going to be a small number of schools. But for example, for 3 prior school years, it meets or exceeds standards on at least 75% of indicators in each section of the performance framework. Secondly, earns an overall growth rating of above or significantly above expectations in the Tennessee value-added assessment system. So in other words, 3 or 4 on a TVOS. And then has no significant audit findings during the current charter term. And we can't forget, and of course that speaks to the financial management of these charters, these individual charter schools must be financially, fiscally managed well. So this is a very high bar, in my opinion, and that's what this legislation does in order for a school to earn that reauthorization for 10 years. Thank you, Mr. Chairman.
Thank you. You have one follow-up, Representative? Representative
Thank you,
King,
Mr.
you're
Chairman.
recognized.
Does this assume there's no change in the leadership of the school and that the same people who are doing such an excellent job are still there? Is that continuity? I guess trying to understand, how do we assume that what happened, we're saying 10 years, would be automatically what's going to happen going forward?
Representative Chairman Slater.
Thank you, Mr. Chairman. And that is an excellent question, because when it comes to continuity of leadership, that is very important when it comes to the success of charter schools. That is currently in the framework of charter schools. When there is a change in leadership, then there are already mechanisms in place in our charter framework to address those things. But you are correct. It is very important as it relates to changes in leadership. Thank you, Mr. Chairman.
Thank you. Thank you. Members? Have no one else on the list to ask a question? Do you have any final statement on this, Chairman Slater? Okay. Any objections to the question being called? We're on House Bill 2177. I see no objections. So, Madam Clerk, would you put the vote on the board? Madam Clerk, take the vote.
Mr. Chairman, you have 13 ayes, 3 nays, and 1 present not voting.
Okay, House Bill 2177 receiving majority moves out to GovOps. Thank you, Chairman Slater. Let's move on now to Chairman Haston. You've got item numbers 15. House Bill 226, you've got a motion in a second.
Thank you. I believe I do have an amendment, 14437.
Motion on the amendment.
It does rewrite the bill, members. You got a motion, second. Any objection to adding the bill for proper discussion? Hearing no objection, all those in favor of adding the amendment to the bill, please indicate by saying aye.
Aye.
Opposed? The ayes have it. Chairman Haston, you're ready to present your bill.
Thank you, Mr. Chairman. This bill simply is a 1 to 2% increase in funding for our smallest school districts that have 1,500 or fewer students. With that, I'll be glad to answer any questions.
Everybody hear that? Make sure the mic up there. Everybody hear that? Okay, with that explanation, kind of sits tall in the seat there, so make sure everybody could hear that. Representative Reeves, you have a question. There you go.
Yeah, thank you, Mr. Chair. So we heard this in K-12, I think last week. It's all blending together a little bit. I have concerns anytime we're changing the TISA formula, and as a representative from Williamson County, one of the very least funded under the TISA formula, I have to kind of raise questions every time I see a proposed change. And I think I heard in subcommittee that this would not reallocate dollars already under TISA, but it would require more dollars go into the formula. Is that correct?
Chairman Slater, Chairman Haston.
That is correct, yes.
Okay, thank you.
Members, further discussion. Chairman Haston, could you go one more time, explain the significance of what we're doing for our smaller communities?
This bill is, it simply raises the, this bill is a 1 to 2% increase for our smallest school districts, anything that's between 1 student and 1,500 students. And to Representative Reeves' question, it is an addition. It's not going to be taking anything away. The fact of the matter is that, there's some inherent difficulties in the smaller school districts, hence the weights that are there to be monitored and adjusted as need be. Some of the teacher salary mandates that have come in, some of the teacher losses that we're seeing from larger districts pulling some of our teachers out of smaller districts. We're losing a lot of funds. Our economically disadvantaged funds are going to be going away, which is going to hurt a lot of our smaller districts the most. And just the fact of the matter is there's just not as many local tax dollars coming into these smaller districts. Now, some of these costs have been covered up by some really, really great CTE initiatives. That's helped the larger school districts really cover up a lot of this, a lot more than our smaller districts. Some of the districts that don't even have CTE programs. So that's the way some of these losses have really been covered up successfully in larger districts and aren't hurting them as bad as it is at our smaller districts. And so a lot of the smaller districts have reached out saying that this would help a lot. It's 23 school districts that are underneath or 1,000 and fewer, and there's 14 districts that have 1,000 to 1,500. So you're looking at helping significantly you're looking at 37 districts there that are going to be helped significantly by $6.5 million per year annually added to the budget. So that's a little bit more detail on what the bill does.
Thank you. I think Representative Johnson has a question of you.
Yes, just a quick one. Has this been funded in the governor's budget, or will this go behind the budget if it's passed? Because you said it adds on, it doesn't cut into anything.
Chairman Haston.
I have 99.9% certainty that it will be behind the budget. Actually, I'll say 100%. We'll go 100% on that. 100%.
Well, thank you for looking after our smaller community. A lot of times they get hit, and we need to pay attention to that. Further questions on this particular House Bill 226? No questions? Any objections? The question being called? Hearing no objection. Madam Clerk, put the vote on the board. Madam Clerk, take the vote.
Mr. Chairman, you have 15 ayes, 0 nays, and 2 present not voting.
Thank you, Madam Clerk. House Bill 226 received a majority, moves out to Finance. All righty, let's go to item number 16 on our calendar today. You got a motion second on House Bill 1838. Let's get it in proper position.
We are actually, I'm going to request to roll this to the hill of this calendar as we are waiting on an amendment on this. I'm at the mercy of the committee, but I would request a roll to the hill.
Okay, without objection, we're going to roll House Bill 1838 to the hill of the calendar. That brings us to item number 17, House Bill 2103 by Representative Stevens.
Thank you, Mr. Chairman. I don't have any amendments on this bill.
You have no amendments, so therefore you do have a motion second on the bill. You're recognized.
Thank you, Mr. Chairman. This bill adds Western Governors University as an eligible institution under the Tennessee Strong Act for active members of the Tennessee National Guard to receive tuition reimbursement.
Representative McKenzie.
Thank you, Mr. Chair. And, while I And I'm going to support this bill, but as I told them, they're an out-of-state entity, taking a whole lot of state money, and they're here every year. I'm just going to ask us to consider, if we're going to do these things, if we're going to take care of our veterans, let's do them with in-state resources. You know, we got a great Austin Peay State University up there right next to Fort Campbell. We have agencies across the state, whether it's CTAD, the TCATs or the community colleges. We have a lot of entities to be given these many breaks, this many to an out-of-state private for-profit entity. I just say let's pump the brakes on this one. I'm going to support this one. I told them I would, but take a look at it, at what they've been asking over the years.
Thank you. And that's a point well brought up. I appreciate that. This is something we deal with year after year. Limited amount of money in the Strong Act. We do put a limited amount of funds in there whenever we want to expand the program. I would like to ask a question. I've asked this question about caps on the Strong Act. The fiscal note in here is $75,260. Legal, would you be able to address, is that the total amount of money in the Strong Act, or is that a yearly cap? With that objection, can I go out of session, ma'am? We're out of session. Legal, do you understand my question?
Thank you, Mr. Chair. Katie Robertson, Legal Services. The fiscal note provides that the increase in expenditures for this bill and related to the expansion of the Strong Act is assumed to exceed $75,000 in FY 27-28 and subsequent years. And it also provides that the current fund balance for the Strong Act is covered for the additional students that they're projecting to enroll pursuant to this bill.
For this year?
Yes.
Now, if we come back next year and we have more students, then would it be a correct statement that the General Assembly had to put more money into this act in order to address the number of students that need it?
That's possible that
Okay.
could happen.
Anyone else okay. Anyone want to ask a question while we're on the bill? Okay, with that objection, we're now back in, you have it on the bill? Okay. Okay, Representative Keem, you have a question of legal?
Yes, sir, if I may. Okay, when it comes to the number of people and the monies that are being put forward, do we have any, I don't know if there's a need for checks and balances as to graduation rates of these persons, or basically, are we getting our money's worth? I don't have a problem with, I'm going to vote for it also, but do we have any guardrails to sort of ensure that this is something that's working in the interest of the veterans and the community as a whole?
That's addressed to legal. Okay, legal, you're recognized.
Either legal or you, Mr. Chairman.
No, there's nothing currently in the Strong Act that that is anything of how you're describing, or anything in the bill to do that.
Thank you. Anyone else of legal have a question? Seeing none, we're back in session. Members, we do have a member of THAC. We have one from WGU. If y'all would like to get a little more information on this, and we can have one of each of those proposing. Reverend Stevens, would you like to have them come up and address some of the things?
If the committee believes it's necessary to hear it.
Anyone would like to have THAC come up, or? You like to hear? Okay, with that objection then, we're out of session, and I'd like to ask Lou Hanneman, who represents THAC, to come up, and also Ginger Hauser from WGU. If you come up also, and we can, the committee. Before I let them make a statement, does any committee member have a direct question of one of these? Yes, sir, you're recognized.
This is before they make a statement?
Well,
Yeah,
we're out of session.
Yes, I do. To Mr. Lou there. When we were in higher ed, you brought up how we have theoretically legislated ourselves out of money in the Hope Scholarship, because the original intent of the Hope Scholarship was based on 4, I believe it was criteria or whatever. Now we're up to 13, and now we're pretty much out of money in the Hope Scholarship. Is this where we're headed with this one as well, if we continue to legislate and add more hands into the pot? Because I think that's what we're doing here. We're continuing to say, yes, your hand can go in, your hand, your hand, your hand. And we're finding ourselves in this situation. Is this what's about to happen if we continue to do this?
Mr. Hanneman, you're recognized.
I think that's conceivable. I will say just on the front end that the STRONG Act is the one financial aid portfolio or program in the state that's not administered by THEC or TSAC for that matter. It is administered by the Department of the Army. That being said, you know, we've worked with them over the years to align that program as closely as possible with our own. And so some familiarity says that if you're operating on a fixed pool of funds for a period of time that needs to be reinfused as funds get lower, then yes, the more access you grant to that pool of funds, the quicker it will go away, and therefore the quicker it will have to be replenished.
You have a follow-up? Okay. Representative Reeves.
Thank you very much. One of the things that I've heard a lot about WGU is that you're not an in-state institution, and we've got to change Tennessee law in order to include WGU in various different things. And I would like to hear somebody address that argument so that, you know, I think this committee can kind of evaluate on that on its merits, if you would.
Ms. Hauser, why don't you take a minute and address that, and then we'll come to Mr. Hanneman.
Mr. Chairman, thank you for the opportunity to talk to you today. Ginger Hauser, Director of Community and Government Relations for the Southeast. Been in Nashville for 34 years working in higher ed and government relations. Thank you for the question. To give a little bit of background, there is a unique part of the statute in various places that addresses WGU. For those of you that have been around as long as I have, I think the chairman has been, and that may be it in this room. Governor Haslam, when he established Drive to 55, were looking at opportunities of how do we get a trained workforce. And one of those opportunities was Promise, Reconnect, the kinds of things that you all are discussing today. The other piece was how do we serve those adults? And how do we get them, those 30, 40-year-olds, to get a degree to contribute to the workforce and are really workforce-oriented programs and that are low cost. Governor Haslam recruited WGU to come to Tennessee. We signed an MOU in 2013. With that were some special things put into the statute because we have a specific memorandum of agreement with the state of Tennessee. That is unique. Part of that agreement requires that we have a Tennessee office. Part of that agreement requires that we have a Tennessee chancellor, my boss. So being very nice to her and say good things about me. Dr. Kim Estep. She was recruited away as the provost at Nashville State Community College. So she was already here in state working in higher ed. And the governor's office and a THEC staff member recruited her to leave Nashville State and to take that WGU chancellorship. And she has stayed the whole time. We have an office in Tennessee in Representative Bolso's district and have been in that space the whole time for 13 years. Part of that was that agreement. We also have an advisory board. This is sort of unique, I think, to any other private school that operates here. Part of that agreement is an advisory board specific for Tennessee, and the governor makes recommendations to the members of that board. So that in statute and in agreement is really unique. part of what we agreed to do is to have staff here to really stay affordable. So we are less expensive than many institutions. In exchange, our students, and this was part of the agreement in 2013, do get need-based aid, do not get HOPE, do not get Reconnect, do not get Promise. We came with this bill because we discovered through some research we were doing on something else that we had Tennessee Guard members who were coming to us and not allowed to use their educational benefits. And we dug a little deeper to see how are they paying for it. And Tennessee Strong is last dollar. That might be important for you to know. And a student has to pass the class. There was a former question on accountability. A student pays up front, has to pass the class, so that's a level of accountability, then files the paperwork to get reimbursed. So they do have to pass. They do have to do the work, regardless of whether they're coming to WGU or any other institution. So that is the way that that is designed. When we discovered that we had some Guard members that were taking out loans that are here in Tennessee, serving the state and serving their country and going into debt, and these are usually 30, 40-year-olds with families working full-time, it just honestly, as somebody who went to school on Pell Grants, it just hurt my heart that they were taking on debt. So I just said, we got to do something for them. And that's why we came to you with this bill. We were going to have a Guard member come to you and testify today. And a few days ago, he got put on orders, and he's at Smyrna and he can't leave. Those are the kind of students that we serve that are working, have families. These are Guard members also, and trying to juggle all of that. And that's why for these 53 students, we're the right fit. And it doesn't mean that we're competing with any of the others. It's just for some, it's the right fit. And we want them to be able to use the benefit you gave them with our institution so they don't go into debt.
Thank you. Representative Reeves, that addressed your question. But let me go to Mr. Hanneman. Did you have to respond at this point in time or just wait for a question?
Happy to wait for a question. I'm just to piggyback on one comment that was made about them being out of state. When that MOU was signed, an explicit effort was made to incorporate them into the TSAA eligibility. That's the statutory exception that we have on the books for them right now. So.
Okay. Representative Reedy?
Thank you, Mr. Chairman. And members, let me paint a picture. Now, first, what I'm going to do is read the caption on this. As introduced, adds Western Governors University as an educational institute at which an active member of a federally recognized unit of the Tennessee National Guard may receive tuition reimbursement through the Tennessee Support, Training, and Renewing Opportunity for National Guardsmen, known as the Strong Act of 2017. So as our military men and women, as you know, at times they get activated, they go. And when they go, they still have access to the internet. So they are still getting an education. That's right. I've been there, done that. Now, part of what they're doing is not only bettering themselves and their families, but keep in mind, every time that I would take and put in for a promotion, they wanted to know, have I been upping my education level? And so they will take and look at degrees and says, Specialist Reedy, we see that you moved that, go to the E5 board, you qualify, now you're an E5. And it's a lengthy process when you go in front of a bunch of sergeant majors and they're drilling down on you as a young buck sergeant. But what we're doing today is saying, hey, it's okay. You go to the Middle East where we, the state of Tennessee and the United States, need you, but continue our education while you're there. And yes, when there's downtime, you're looking at four walls going crazy. So if you've got an outlet that you can collaborate with other guardsmen as well as other people in this class, it makes a world of difference. And when they get back, they're going to be more thankful to Tennessee than when they left if they have this opportunity. Thank you, Mr. Chairman.
Thank you, Representative Reedy. We're still out of session. Anyone else want to comment while out of session? Representative Hurt.
Thank you, Mr. Chairman. I just want to take a second. I carried some legislation for WGU a couple of years ago, and maybe you can speak to it. I know that the fiscal concern was mentioned earlier, and it is a concern. But what I learned going through the process and learning about WGU is the efficiency and the productivity that they have for the cost or for their tuition costs. And maybe you can give us specific numbers, their job placement, they are meeting these students where they are. And we send a lot of money to higher ed across the state, but there are not many that can compare to what WGU does on their job placement and using those degrees after they graduate. So could you speak to that for just a second?
Thank you, Mr.
You
Chairman,
recognized.
and thank you for the question. Yes, our job placement rates are very high compared to most. Now, in fairness, the caveat I will give you, because we serve folks in their 30s and 40s, is we have folks that are working and may switch careers. The guard member that was going to come as a machinist right now, he's studying IT. So he wants to go from, this family supporting wage to probably upper middle class, right? So he's an example of shifting careers. But we also have many that it's a career advancement. So they might be, let's say, an RN nurse. They get a BSN with us and they advance in career. So we have two types of students, those switching and then those advancing. So almost all of our students are working and going to school, advance and switch careers. The other piece I think you mentioned was the fiscal note is our Senate sponsor, Senator Powers. The budget amendment that was filed, and I shared it with the chairman and I can share it with you, gets to that ongoing cost piece. It refers to the act you passed last year where you added money into Tennessee Strong and renewed it ongoing and didn't sunset it. It refers to that and says the pot of money that's sitting there in alignment with the fiscal note, $75,000 is earmarked to cover the 53 students. And then it references this bill this year and says ongoing for next year and in perpetuity, that same amount is allocated for students. So, and I can share that with you all. The intent of filing that way, and we worked with Senator Watson's staff member and legal to craft it to mirror that fiscal note, is to have this placeholder so that it doesn't necessarily exponentially grow. And that was really intentional to say, for the folks that we're serving, we want to do right by them. We want them to be reimbursed and not go into debt. But let's not go the way of the challenges you're having with Hope and others right now, to be reasonable to serve those. So hopefully that gets to kind of the cost question. Our tuition does remain low. It's $8,200 a year or so for a full-time student. Our model is that you can take as many classes because it's competency-based as you want. So many people will finish a bachelor's degree coming to us if they transfer in a year. Instead of it taking a few years, they do it in a year. So they could actually get a bachelor's degree, for $8,500. The same is true with master's degree. They can go as fast as they go. So we have had teachers, for example, that are off in the summer and that just 8 hours a day do online education, and they've gotten a master's degree in a summer. So that means they've gotten a master's degree at a really inexpensive price. Now it requires you being dedicated and focused. This is not the modem if you're looking to just have a good time. This is for adults usually focused on a workforce, IT degree, teaching, nursing, business. And if they're focused and ready, they can get through quickly and affordably.
Mr. Hanneman, this is the part that confused students. Thank you for being here today. We appreciate you. Mr. Hanneman, quick question before we go back in session. Where I'm stuck on is the $75,260. Is this the total amount that's in the Strong Act for all our public universities within Tennessee, or is this?
No, sir. I'm sorry. Thank you, Mr. Chairman. As I understand it, there is an appropriated fixed amount of money available to the Strong Act over the course of several years. I think what Ms. Hauser was saying is that earmarked from that pool of funding is an amount of $75,000 each year for specifically the students noted in this bill.
Okay,
So
thank,
it will come out of that pool of funding, but it doesn't, there are available dollars in there that the students in the Strong Act are, utilizing at all of the institutions. I think the fiscal note speaks to $75,000 specifically will go to these students.
okay, and that's if you come back next year and there's 100 students, this cap would have to be changed, right?
They would either have to change it or do a lesser amount, not quite last dollar.
Okay.
I'm not sure how that would all work programmatically.
Thank you.
I would definitely ping the education group
Okay.
over at the Army.
Okay, anyone else while we're out of session? I see no hands. Thank you all very much. We're now back in session. Chairman Sapiki, I think you had your hand up first.
Thank you, Mr. Chairman. I do apologize, but I did make it through state and local, so keep hope alive. Whew. Members, WGU may be a great institution. It may provide a great opportunity. We have been very cautious in the General Assembly of sending money outside the state of Tennessee when it comes to education. We had a robust debate here a year or two ago when Commissioner Holt wanted to send money for special needs kids outside the state of Tennessee, and we put all kinds of protections in there in place. WGU made a promise to the people of Tennessee about teachers, and they did not deliver. They did not deliver to us. Now, I know we have Chairman Reedy here, who I have the utmost respect for in his service to our country, and those individuals like Mr. Representative Glenn, who served our country. We owe you a debt, but we owe you a debt in the highest level to make sure you're getting the best that we can provide for you. Austin Peay, University of Memphis, University of Tennessee Martin. There are universities in the state of Tennessee that have this type of availability for our service members that they can take advantage of. That we, through THEC and those universities, we have purview over the quality that they deliver to our servicemen or our students. Please be very cautious of opening this up, because they're not the only one that's going to want our money. You got to be careful here. I'm asking you for a no vote on this bill, and let's keep the money here in Tennessee under universities that we have purview over, that we can maintain high quality for our service members if they want to take advantage of it. Thank you, Mr. Chairman.
Thank you. Let's go next to Chairman Raper. You haven't spoken yet. You're recognized.
Thank you, Mr. Chair. I want to ask a question to the sponsor. Does this open Pandora's box about other out-of-state colleges, universities, as far as they may come and have a legitimate reason that they're wanting funding, and it could be very, very legit, okay? Do we owe them to also pass a bill to enhance them? Are we opening Pandora's box? Is there an end to this?
You address that to the sponsor, Representative Stevens.
Thank you, Mr. Chairman. Certainly, any institution we welcome to come and ask. I think you would have to look at each one based on its merits. This one does have a connection to Tennessee. Personally, I don't have an issue with the choice that the service members would have if they wanted to use the funds to go to a different school out of state. If they're serving our country, I believe that they should have the option to use the funds wherever they want to. And so if other ones come, we'll have to look at that and, evaluate the budget and so forth at that time. But I will say that not all of the universities that have these programs are the right fit for the students. Some of them have rigid, like weekly assignments. And if you're on active duty, you may not be able to do that. With the Western Governors program, you can pick up where you left off. If you get sent on active duty and come back, you can pick up and not have to withdraw from your class or miss it. So not all the ones that we have work. Perhaps we could address that with legislation next year to create a program that would work for them. But as to your question, for other universities or institutions coming, anybody would be welcome to come, and we would have to evaluate that then. And like I said, I personally don't have a problem with our service members using their benefits wherever they want to.
Okay, we've got about 5 minutes. We have a hard stop at 1 o'clock. Let me go to Chairman Bosso. You haven't spoken yet on this bill.
Thank you, Mr. Chairman. I simply want to build on Chairman Dridi comments, which I thought were very moving. And with all due respect to my great friend from Murray County, Chairman Sapicki, I'd rather follow the guardsmen than follow the dollars. I mean, obviously, WGU is providing a service that these guardsmen have selected. There are 53 of them, and they've said yes to our state and our country with their service. And I think it would be impolite at worst to say no to them. I mean, they have looked at these other options that were available from other institutions that have a physical presence within the state, but they've decided, as others have, that WGU provides something to them that these other institutions cannot provide to them. So I would ask for a yes vote on the basis that we want to keep our eyes on the guardsmen and what they've selected, not on where the dollars necessarily go. Thank you, Mr. Chairman.
Thank you. Representative McKenzie, I'm back. No, he's not in here. Representative Johnson, let me go to you next and a few more, then we'll wrap it up.
Thank you, Mr. Chairman. I looked around I was here in 2013, and I think you were, and it might have been just us, but in 2013, when WGU came here, I remember it vividly because I remember that WGU was coming into many states that year, but Tennessee was the only state that gave them $5 million to come here. No other state where they came in at the time on that list that we saw had given them money. Tennessee was offering them $5 million. And as my colleague from Knox said, it's been continual since then. So because there are other places in the state that our guard folks can get those, it's really hard for me to support this when we have been, from the get-go, we have been funding this private college and with, at times, questionable results. And so I want to help the guard members, but I just can't in this instance where we continue to do this and there's no promise of what we're getting out of it.
Representative Reed, did you have any more comments? You're okay. Representative Glenn, you're okay? Still had you down here. I mean, right here. Glenn, yeah, I had you down. If not you, I go to Representative Hakeem.
Thank you, Mr. Chairman. There were comments made earlier, I think could put the university in a negative light. And if they wanted to respond to it, I would hope that we would afford that opportunity. And in addition to that, what has been the results over the years they've been here in regards to our veterans and how has it helped them to move forward? I don't know if I need to go out of.
Well, we were out of session. We got 1 minute left. Why don't we just move on if it's okay? I think we've had a lot of discussion if you agreed on that, since we're down to 12:58 right now. Any further discussion? We're on House Bill 2103. Any objection to the question being called? Hearing no objection, Madam Clerk, please put the vote on the board for House Bill 2103. Madam Clerk, take the vote.
Mr. Chairman, you have 8 ayes and 7 noes.
Okay. House Bill 2103, having received a majority, moves out to Finance. Thank you. Great discussion, members. I tell you what, until members, we are going to recess until 1:30 tomorrow, back in this room to finish the calendar up, hopefully. Thank you for the great discussion, Dave.